we're saying there's no areas of the mining area that can fall to be considered under the SNA. So I've just noted there the legal counsel from the District Council and the reporting officer's position in terms of the already identified, and I've set out why we don't consider that an ability to meet the criteria is sufficient to meet that requirement already identified. And I've referred to words there at paragraph 37 in terms of the area and already in terms of the specific area and the wider context, which suggests that identification requires both a textual and mapping identification. I also note that the RPS policy 7.1 also states that areas of significant Indigenous vegetation and habitats will be identified using criteria in Appendix 1, and they'll be mapped in the relevant regional district plans. The point I've just made there is it doesn't make any sense that an area meeting the NPS-IB SNA criteria must go through a plan change to be incorporated in order for it to apply to be SNA by virtue of the NPS. So we talked about that in the opening submissions, that even if you're identified through a resource consent process under the NPS-IB, you're then required to go through a plan change to consider whether or not that area will end up as an SNA in the plan. So it makes no sense that that an area meeting other prior criteria would get preference and is automatically deemed to be an SNA without the need for a plan change. Off the back of that. In terms of ecological significance, and there was obviously thorough questioning of the experts, I don't intend to go through that, but I did want to identify the note that sits directly under the Appendix 1 RPS, and I've set that at paragraph 40. So under the Appendix 1 criteria, it says, note, these criteria are intended to be applied by a suitably qualified and experienced ecologist with a good understanding of the local and national context and its associated ecological tools. And then I've just referred to the statements of evidence of Dr. Keesing and Dr. Bramley and their qualifications, which are very extensive, and they're specific and numerous examples of complex work that they have achieved in all the different districts on the West Coast, and they have that relevant ecological district experience. They've also undertaken significant wetland identification and assessment, and their independent opinions are aligned and should be preferred over the limited experience of Mr. Payne. And I've set out an opening that I just wish to say the panel should be cautious in interpreting a difference in assessment as something that's inadequate information. But I see that Ms. McGrath has accepted there's sufficient information there. As set out in opening, Dr. Bramley was engaged to review the differences between Dr. Keesing and Mr. Payne, and he has actually carefully set out in his evidence those differences and reference should be made and full to that statement of evidence. The only other thing I'd note is that Mr. Payne accepted in response to questions that when you consider the removal of those forest fragments at an ecological district, there is a negligible effect. And that's the scale of assessment that's required in the RPS and the NPS-IB. But he also then tried to sort of downplay that comment by saying that you could also clear the Mahinapua Reserve in the context of the ecological district, and it would also be a negligible ecological effect. But however, he did not acknowledge that the RPS criteria explicitly provides for the different circumstances associated with that area insofar as they attribute significance to Indigenous vegetation or habitat of Indigenous fauna that is a relatively large example of its type within the relevant ecological district. So there's 2 points under that representative test. So I just want to point those bits out. But otherwise, I think the questions have been thorough. With respect to noise, the peer reviewer, Lindsay Leach, continues to recommend noise limit timeframes that align with the WDC noise rules, except with an increased noise limit from 45 to 47 on Sundays and public holidays between 7 AM and 7 PM at the nearest properties. So she has picked those limits from the modelling so that the activity would comply if her proposed limits were granted. The applicant's preference is to continue with the more common approach of applying a 55 decibel limit on Sunday and public holidays. Conditions of consent can only be imposed on the applicant if they're directly connected to an adverse effect. And Mr. Farron considers this approach has acceptable noise amenity at the nearest dwellings with respect to the existing noise environment the World Health Organization and standards. It's also consistent with the proposed Type 10 plan, which provides that future indicated notified permitted level, but acknowledging that it's still waiting a decision. The applicant has also offered condition 19.7, which requires the mining operations to use the best practical option to minimise noise at all times. So those limits are obviously the worst case scenario as opposed to what's going to be achieved in practice. And I did just identify earlier in terms of a point up front, Ms. Leach uses the WDC noise standards and Ms. McGrath also referred to those. Those noise standards don't apply to mining. They also don't apply to agricultural or forestry activities based on the way the plan's structured. So using those noise limits as a reference for this activity for Ms. Leach, I would say, my suggestion is not as appropriate as how Mr. Farron's done it with respect to the broader standards. The applicant has offered, and you would have seen in Mr. Lowe's conditions, we've offered the other additional changes in response to suggestions made by Ms. Leach. So we've made changes to the noise management plan, condition 19.1. We've added compliance monitoring for neighbours, and Mrs. Leach's suggestion to include no tonal or reversing beeper alarms is already included in condition 19.8. So the point of difference remains just on that matter. With respect to traffic noise and Ms. Leach's suggestion that the management measures should include explicit reference to engine brakes, condition 17.4 already requires the traffic management plan to include methods to minimise amenity disturbance, including but not limited to location where the use of, and that says air, but it should be engine brakes, must be avoided. For context, and as set out in the evidence of Mr. Lowe from paragraph 46, it is relevant that the district plan does not control the noise effects of any forestry or agricultural activities or road traffic noise relevant to trucks. I feel like we discussed landscape a little bit up front. I guess the point I'd make there is it's significant that Mr. Robinson is accepting that should the evidence of Dr. Keesing be accepted over Mr. Payne, then the effects from his assessment will reduce to less than minor or more than minor but not significant for temporary perceptual effects. In response to questions from the panel, Mr. Robinson does not consider this environment as seen as a rural environment. And he considered the site will have a high perceptual effect from the state highway. As I set out in my opening submissions and was clear in his answers provided to the questions from the panel, nowhere in his assessment does he acknowledge the activity proposed as anticipated by its underlying zoning DP. It's not appropriate to undertake a site visit, a site assessment in a vacuum without reference to sort of the reality, or you referred to earlier, sir, the real world approach being a site productive rural environment. The reference was made to mining being a restricted discretionary activity, and so it's not permitted. I mean, there are elements of mining, prospecting and exploration that are permitted and controlled, but it's really when you look at the objectives and policy, that's where there's enabling policies for mining activities in the rural zone. So it is something that is enabled and foreseen as part of that environment. We talked about the proposed mitigation measures being focused on the sort of more transient passerby as opposed with no respect. And with respect to the comments on the walkway, there was no acknowledgement that tourists may view the site as a matter of interest, given the history of mining in Westland. And I've just referred to that comment was addressed by Dave from Cycle Journeys in his oral submission in terms of, catering for tourism that provides for more than one element. And in his commercial view, he's wanting people to come and visit the coast for a number of reasons, and he saw mining as being an opportunity for that. Mr. Robertson also lacks due consideration in my submission of neighbourhood amenity. And he made the comment that some people who live in the rural landscape, it's going to be a big problem. But I just think it ignores the reality of the limited submissions that were made by the local community on the visual effects of the plant. We agree with the panel's line of questioning around the Westland District Plan being the proxy for the community's view on mining. And I think this is supported by the application being expressly requested to be publicly notified, but the fact that all there was ended up was 4 people within the Mananui and Ruatapu area that seems submitted on this application in opposition. Rivers on the application side, at paragraph 54. We heard orally from Mr. Rika that in accumulating wet periods, there were shallow areas of water built up into Juno pollards, which occur between the natural and cleared areas. And it appears that historically these areas' water would have limited the pastoral production of the farm, and a logical response was to drain them by cutting through the dune ridges and out to the wetland. My understanding of the evidence is that the wet areas would not flow along the surface until they were linked up by those cut-throughs or drains and are too high to intercept the water table. And in my submission, that does not meet the definition of a river. There is no evidence which suggests that drains A, B, and C are rivers. I've just set out at 56 the RMA definition of wetland, which is in the Land and Water Plan, because it gives local context. The wetland definition specifically excludes areas of pasture where water ponds after rain. And the definitions from clause 3.21 of the MPSFM, so that's the natural inland wetland policies, have now been incorporated into that plan as well. With respect to the question of whether the habitats of Indigenous freshwater species are protected within the farm drains, I thought it was a really interesting question raised by ELI. So when you're having regard to that policy, policy 9, I don't think that such an assessment is excluded. I think you're able to consider whether there is a habitat in a drain. However, I'd exercise caution in taking this approach because it's entirely relevant that, it's subparagraph A, that, to form a drain and to maintain a drain is a permitted activity. So you can do that without consent here on the West Coast. The regional council functions include maintaining biodiversity and control on the maintenance enhancements of quality of water and ecosystems and water bodies. So water bodies is defined to mean fresh water in a river, lake, stream, pond, wetland, or aquifer, and it's not located within the coastal marine area. So it doesn't seem to be inferring that that function would extend to looking at drains. With respect to the policies under the MPS freshwater that were required immediately to be put into the council's plans, they related on to the loss of extent and values of rivers and natural inland wetlands. And when you look at the MPS freshwater, the NES, on freshwater, there are resource consent requirements that apply for the reclamation of the bed of the river, which requires you to show the functional need and apply the effects mitigation hierarchy and in relation to natural inland wetlands. So there's no kind of emphasis or immediate requirement that would give drains any significance in this situation. I do accept that if you read the plain words of policy 9, which is protect Indigenous, protect the habitats of Indigenous freshwater, that you could read it that way. The other thing I just wanted to observe was that when you look in the MPS freshwater, when undertaking the NOF, the National Objectives Framework, which the councils are required to do, they're required to identify freshwater management units. And as part of that, they need to look at ecosystem health, which has to have 5 components. One of those is habitat, and that habitat is explained in Appendices 1A, and it talks about the extent to which an FMU or part of an FMU supports an ecosystem appropriate to the type of water body, for example, river, lake, wetland, aquifer. So, I think it would be a very unique situation where a drain might end up in that freshwater management unit, but I'm not excluding it on the basis that, they have a function of transporting water often to a body. And for the most part, when you look at the scheme of the freshwater national policy statement and the associated regulations, they don't apply to farm drains. I've just noted that the stock exclusion regs apply to rivers over 1 metre, termed wide rivers, and the exception is under the NESF, where setbacks are required from drains in certain circumstances, feedlots, stock holding areas, and intensive winter grazing none of which apply here. The NES freshwater uses the definition of drain from the National Planning Standards, and that's set out, it's paragraph 60, any artificial watercourse designed, constructed, used. And in my submission, the drains A, B, and C identified in the evidence of Dr. Keesing would be clearly within the definition of a drain. Yeah, I think that sort of doesn't need to be a big issue arising. I think on the evidence, it appears that the experts are in agreement that it's not a river. It's difficult to understand without a source or a discharge how you could meet the flow. When I was listening to the legal submissions made by ELI, they started with the concept of a wetland. But when you interpret the relevant MPS freshwater provisions around rivers and wetlands, they're now utilising the district plan or the regional plan definitions, which sort of exclude ponding areas and exclude stormwater drains and things. So, yeah, I didn't think it took too much significance, but did think it was an interesting question and that one that could have relevance in some circumstances, but in my submission, not yet. And you'll know from the conditions that obviously any fauna in the water is proposed to be relocated out of those bodies. Compliance with consent conditions. A number of questions were raised just in regards to how we intend to comply with, or the applicant intends to comply with conditions. I've just cited case law there that the applicant's entitled to a presumption that it will act legally and in accordance with its consent conditions. This is a well-established principle of resource management law, and there's no, I guess, evidence here that would suggest that wouldn't occur. In terms of notification to neighbours of potential risks to drinking water, condition 28.2 provides for the situation that if the water quality thresholds are exceeded, it requires the notification of down gradient well owners. And Commissioner Geddes, you asked me just to confirm with Mr. Rika about what that time period looked like in terms of the flow of water. So Mr. Rika has advised that if a threshold is exceeded in that area of testing, it would take a worst case scenario of 30 days and on average more likely 90 days for a water quality issue to materialise, which is obviously isn't expected, but if it did, on this basis, we may consider changes that are required.
The timing works, yeah.
Yeah, plenty of time, but it's a good question. At paragraph 66, ELI seeks monitoring and management of the little blue penguin. This isn't considered necessary for the application site. Dr. Bramley considers it is possible but unlikely that korora cross the site to reach nests or perhaps nest in the site itself. And I just want to flag that the applicant has a partnership with the West Coast Penguin Trust, who made a neutral submission on this application. And the key points from the Trust submission includes that the Trust has a relationship with Westland Mineral Sands based on transparency and positive advocacy and actions for the benefit of penguins and other threatened seabirds. Mortality and breeding survey records indicate very few penguins in the Mananui coastal area and not on the application side of the highway. The mortality records clearly show that the single biggest killer of little penguins within the West Coast region is vehicles on coast roads. The Trust has discussed little penguin mortality on State Highway 6 between Hokitika and the Serpentine Corner with Westland Mineral Sands, and the Trust has promoted driving slower at night at certain times of the year when penguins may be crossing the road, and looks forward to continue working with WMS to implement appropriate driving conditions and contribute to penguin safety. So just flag that condition 17.4H requires a traffic management plan to include methods to assist drivers to identify and minimise harm to little blue penguins, and acknowledge that Applicant values its close working relationship with the West Coast Penguin Trust and will continue to engage with them, including with respect to any interactions of the mine or drivers with korora. Lizard surveys are actually continuing to be occurring on the application site. So while it's not provided in evidence or the conditions, Ms. King is a qualified herpetologist and she manages the process on the 9 Mile site. And I understand she's actually the herpetologist that found the little the West Coast green gecko in the forest too. So if anyone can find them, we're confident Ms. King can. But with respect to the conditions of consent, lizards are assumed to be there. But like I said, monitoring is going to continue ongoing, even though none have been found, and the conditions of consent are provided on this basis. Lizard management methods are set out as a requirement for the fauna management plan and include search methods and effort to be implemented to identify and capture lizards prior to vegetation clearance occurring, and protocols for the relocation of lizards and vegetation that may contain lizards, including direct vegetation transfer, no mulching, and careful handling. And Mr. Lowe took you through some amendments to that condition. So after listening to Mr. Payne speak yesterday, the applicant will also investigate alongside a herpetologist the possibility of transferring the larger trees with complex epiphyte assemblages using machinery that is capable of holding and laying down the cut trees without the impact of a typical tree felling to minimise that harm. And then I just overall rounded out that Dr. Bramley agreed with Dr. Keesing that while it's possible there is suitable habitat for lizards, given the difficulty in reliably detecting lizards, particularly that species, it's not uncommon for a project to identify the presence of suitable habitat without confirming the presence of lizards. So search and salvage of lizards is never completely successful, and the extent to which it is successful remains unknown. Some individual lizards are known to survive the DVT or VDT process, but again, there's no sort of firm data on that. Mr. Bramley notes that lizards are known to be vulnerable to predators, particularly rodents and feral cats, and effective predator control as proposed is likely to benefit them. And he considers that implementing the actions proposed according to best practices set out in the proposed lizard management plan represent that all that can be realistically be done on the effects of lizards. But it is something the applicant's very mindful of and will continue its efforts. And that brings me to a close in terms of key changes to conditions, which Mr. Lowe's actually already addressed. So you'll be happy. Unless there's any questions on that.
No.
No, I can't see.
I think we're all done and we can all head off.
They're all cooked.
Yeah, maybe like a few days.
All right. Well, that brings us to the close of the formal part of the hearing, which is not closure in the sense of a formal determination that the hearing's closed, because we haven't had a chance to dialogue between ourselves and identify anything else that's required. But we think it unlikely, so we're probably likely to formally determine the closure reasonably promptly. I'd like to thank the committee administrators, Kate and Tin, for their efforts in keeping this process running smoothly, and it's greatly appreciated. And I believe it's quite a learning curve for both of you, so hopefully you've enjoyed it, and you've done very well. And to thank everybody else for their participation in what has been a very interesting and again challenging matter that throws up incredibly important ecological values and things of that nature. And so I appreciate the professionalism of everybody in terms of addressing the matter, and I look forward to working with my commissioners to release a decision as soon as we can. So thank you very much.